how do we preemptively deal with this? Like handbooks, policies, what do you recommend to not get ourselves in trouble down the line?
Absolutely. First thing I'll say don't do is don't download a handbook. Don't download an independent contract agreement online. I had one client that did this, that downloaded their own independent contract agreement, and everything in the agreement said proved that the person was an employee, not an not an independent contract. It was like
Oh my
you.
God. Hi, everybody. I'm Beth Hochberger, CPA, CGMA, and welcome to Finance Friday, where we are going to be featuring this amazing gentleman here. Let me do a quick bio real fast. So, Brandon Campbell is a principal in the Orlando, Florida office of Jackson Lewis P.C. He regularly handles complex disability, leave, and health accommodation issues, complex arbitration issues, defamation, negligent retention, Florida common law employment / harassment litigation, and non-litigation matters such as RIFs, employment agreements, and severance agreements. Oh my goodness, it sounds like a lot because it is a lot. Welcome, Brandon.
Thank you. And a short story is that I just help out employers of all sizes. I have a very strong small business practice, and I think that's also consistent with Beth's practice too. And that's why I'm here. I'm here to give you some common issues, I see with small business clients, how some of those issues cost them hundreds and hundreds of thousands of dollars, and how you can avoid those issues. I'm happy to be here.
Employment issues, I will say, is probably like one of the scariest things for small business. And it's something that sneaks up on you quickly because if you
Yep.
start like a normal kind of pattern of like, it's just me, and maybe I have some like 1099 contractors, and oh, this is working, let me hire people. It's like all of a sudden now I have to worry about this stuff, right? So for the like small businesses, what do we watch out for? Because yeah, nobody wants to pay those bills when you get in trouble.
So I'll start with the first thing. The number one thing I see small business owners mess up is relying on the independent contractor title and trying to hire multiple employees as independent contractors. There are obviously many reasons why small business owners are going to do this. Number one, you don't have to worry about all the issues that come up with naming them as an employee, such as things like in Title VII. There are certain employment statutes that only apply to employees. The Fair Labor Standards Act only applies to employees. There are so many different laws that only apply to employees. So by naming them as an independent contractor, you may be able, or the theory at least, is that you'll be able to subvert those laws. That also helps you with employment taxes and not having to
I was gonna
pay
say,
taxes related to.
yeah, like people love to like avoid payroll taxes and like dealing with
Yeah.
payroll because like, oh, they're contractors. It's like, well, they're not a contractor because you didn't want to set up payroll, right? Like that doesn't fly.
So, and the consequences can be bad, right? So, let's start with what's the most common issue. Under that subheading, the most common issue I see it from a wage and hour standpoint, right? If that when someone's an independent contractor, you don't have to pay them overtime. There's just so many different things you don't have to pay them, and you also don't necessarily have to track time. So it definitely decreases the burden on the employer to name them or identify them as an independent contractor. However,
Right.
you can't just name them that way. The law isn't that, hey, just because I call you an independent contractor doesn't mean you are.
Right. And we
Um,
have that with the IRS as well, right? Like they also
right.
have rules where it's like, if you tell them when to show up and you give them equipment and say, follow my process and use my tools, they're really not a contractor. So similar idea.
And really, that's the point, right? So, You know what I'm saying? So the point is that there are so many different tests by many different governmental groups, right? There's a Florida common law test for employees versus independent contractor. That's a multi-factor test. There's a federal test. There's the economic there's a realities test, which is a common federal test for it. There's the IRS test for it, and then different states have their own tests. So there are so many different tests as to whether someone has been properly designated as an independent contractor. So I'm just going to give you some guiding rules,
Yeah.
guiding principles. If you
Yeah, I was
follow
gonna say,
these,
is there an easy way to know what you're dealing
yeah,
with?
I'm not going to sit here and try to break down all the tests, and that's for pleadings and court if in court action. This is just a conversation here. If a general rule, the more control you have over the person, the more likely it is that they're going to be considered an employee. If they're coming in from 9 to 5, if they have to come in, to your office, if they have to report to you ever so often, if you are, if you're saying directing how they are doing the task, if you're telling them specifically what to do, if they're using your tools, as that mentioned, if they're using your laptop, your computer, your office, that is going to further indicate that that person is probably an employee.
Yep. That's similar to the
Yeah.
IRS then, right? So at least it's a little
Yeah.
bit like consistent.
And like you think about what a contractor is. If you think about hiring your lawn company, right?
Yeah, that's a good
The
example.
person that comes to mow your lawn, you don't tell them, "Hey, be here from this time to this time." You don't give them the tools. So you're not outside telling them what to do. Person comes in, there's an established payment. You pay them, they mow the lawn, and you move on. That's essentially what an independent contractor is. Is that
Yeah.
you're just making a transaction, they control how it's done, all the details. You're just making a payment and you're moving on.
Can I throw like a wrench into this whole conversation?
Sure.
Post COVID, right? A lot of people working remotely and they might be working like in other states and things like that. Like I have that even. I'm not that big of a company. We have people in other states. How does that fit into this scenario? Because I know everyone would love to not run payroll, in 4 different states because it becomes such a headache. Remote workers with a small
Yeah.
business in different states. Can we just
Okay.
call them contractors or no?
No, not. It's even more complex when you do that. So independent contractor title generally can also subvert or help you steer away from most state laws too. However, there are many states that have even more stringent laws than the federal law and way more stringent than Florida, which is very, very employee friendly. So
That would
by hiring an employee in a different state, you may be subject to that state's laws,
Oh, okay.
depending on the situation. In many cases, you are going to be subject to following that state's laws.
Oh
If that
man.
that employee files an EOC charge, they're going to file it in their home state. And I see many clients that have employees in states like Colorado, California, Illinois. These are states with very, very, very employee friendly laws. And so by letting someone work remotely in a different state, you may actually be enhancing your risk.
It's funny how much of what you're talking about like is so mirrored in what we do on the tax side because
Yeah.
all those states you listed have problems with like the tax piece of it as well. Higher taxes, more complicated filings, all that stuff. How you do one thing's how you do all things. So you make one piece of it complicated, you're making the whole thing complicated. We're not making anything better by hiring everyone as contractors. We're not making anything better letting them, work in other states. I mean, not better, just we're not making it easier for ourselves.
You're saying delaying a problem, or you're saying gambling, right? So many cases, right, when clients have made that mistake and they're coming to me after the fact, and the plaintiff's lawyer has found out that you've misclassified someone as an independent contractor, there's no easy conversation, right? At that point, when the case gets to me, there is no easy conversation. Most of the time, that mistake in attorney fees, if it gets to a plaintiff's lawyer and now it's gotten to me, that error is going to cost you at a minimum. Let's say I do a great job, I do an outstanding job, and I get the case done for as little as possible. It's probably going to cost you $20,000 to $30,000 in attorney's fees just just to get started. If the case litigates, that's if the plaintiff's lawyer is nice. If the case litigates, it may cost you up to six figures in lawyers' fees, and
Jesus.
you get some additional money in paying off the wages owed. Because if you misclassify someone, they're
Mm,
generally going to argue that they worked overtime. You're
yep.
probably not going to have records or wage and hour records to disprove that. And the general prevailing law is that there's a presumption that the employees just in recollection of what they work is right unless you can disprove it.
Prove it. Gotcha.
And
Yep.
they're going to
Yep.
say, listen, I worked 70 hours a week, and if you don't have any time records, you're going to have a tough time trying to disprove those allegations.
Man.
So yeah.
Okay, so enough. I'm scared, right? Hopefully, other people are. How do we preemptively deal with this? Like handbooks, policies? What do you recommend to not get ourselves in trouble down the line?
Absolutely. First thing I'll say don't do is don't download a handbook. Don't download an independent contract agreement online. I had one client that did this, that downloaded their own independent contract agreement, and everything in the agreement said proved that the person was an employee, not an not an independent contract. It was like,
Oh my
you
God,
will
it's like
do this, you will do that, you will be here from 9 to 5. And I'm like, dude, this agreement they signed proves they're an employee. If opposing counsel gets this, we are in trouble,
right. It's like the
So
exact wrong thing that you found.
that's what the agreement says. Don't go on your chat GPT, say, hey, draft me an agreement that says independent contractor. There is still an art, a human element to practicing law. Get you a really good employment agreement. That's going to help you define the terms, the terms and conditions of a person's employment. The second factor is if you are determined to have someone be classified as an independent contractor, draft a proper agreement. Hire a lawyer. If you want to do business, you want to make money. There is
Some costs.
some level of investment. I like to say invest. I like that.
It's deductible, though. I mean, come on.
If it is, yes, thank you, Ben. Appreciate that. There you go. So, hire a lawyer, have someone draft you a really good agreement. That agreement might cost you, I don't know, $2,000 or something like that. But but after that, you can copy and paste it 100 times. You can use it 50 times after that. Make sure if you're going to have a proper independent contract agreement that you get it properly drafted, that you pay to get it properly drafted. Don't just download one. But then number two, if you really want to have an independent contractor, treat them as such. Treat them as such. You're an independent contractor. Here's what I want you to do. Here's the fee for doing it. Please have it to me by X date. Hands off. If they want to work at midnight, 1 a.m., or they want to do their work between 4 p.m. and 8 p.m., that is their business, right?
That's their problem.
If you can show a court and say, hey, I don't track these people, I don't coordinate with them, I'm not telling them what to do, I'm just giving them a task and I get it back and I pay a fee, that's going to make your argument, you're saying, pretty good. And the more control you have over them, the worse it gets, right? So one, treat them like an actual independent contractor. Another part is that have a lawyer review whether it's worth it, right? Maybe you just want to. Maybe it's easier for you to just hire them as employees. Depending on the number of employees you have, you're not going to be subject to many of the harsher statutes. Most of the detailed statutes start with 15 employees, right? So Title VII, the Florida Civil Rights Act. Most of those require that you have at least 15 employees before those statutes start.
And that's
However,
a sizable company, though. Like, honestly,
if you have that many, you should have a lawyer.
you should have an attorney at that point. And is that 15 like? Does that include like family members, or do they still count as employees?
No, it's not. Listen, if the person is working for you and receiving a wage and you're controlling it, they're probably going to be an employee.
Okay.
If they're just doing side work or they're just a family member helping out from time to time, probably not so much. But if they're coming in to work every day and they're just family, sorry, they're
all right.
Yeah.
We see a lot of family-run businesses, so this is worth asking.
Sometimes people that have an interest in ownership can be considered an employee.
But 15, like, you can hire quite a few people before a lot of this is gonna affect what you're doing, like as far as the
Right.
employment law side?
So I just gave you the primary rule, but there's always an exception, right? Let me tell you what that is before somebody sees this and goes running off like, oh, I can do it again. What? One is the Fair Labor Standards Act applies to everyone. It doesn't have a minimum number of employees, so you never get past the Fair Labor Standards Act. And so just know that you always have to pay employees the proper hourly wages. You always have to satisfy minimum wage, whether it's Florida law or state law, and you always have to pay overtime. So you never get past that, regardless of the number of employees you have. That's number one. Number two is ordinances, right? Sometimes cities have an ordinance that can transition the state law and make it apply at the city level. And those ordinances sometimes, and in many occasions, start at a coverage of 5 employees. Now, there's a caveat. Under the 15 employee statutes, in Florida at least, this is Florida, under the 15 employee statutes, they do allow for what we call compensatory damages. And those damages could be unlimited under the Florida Civil Rights Act. They could be
Oh
a
wow.
number, millions of dollars, who knows, depending on the case. The ordinance doesn't have the same ability to inflict compensatory damages. They can only inflict actual damages, which means that damages that a person can actually prove, like how much did it cost to go to the doctor, or how much did it cost to do X, or so generally speaking, those kind of damages are going to be in the thousands, maybe the tens of thousands. So those are really going to get into the six figures. So at least at the ordinance level, there is less exposure in general under the ordinance level.
I guess that's good if you're dealing with those smaller number
Right.
of employees.
5,
So
6, 7, or 8 employees, not as much exposure there.
gotcha. Okay. Well, Brandon, I don't want to keep you here all day. I think we gave everyone their marching orders at a minimum. They need agreements and handbooks, and don't download it from the internet. Don't have
Absolutely.
AI write
Absolutely.
it.
Understood. Last thing. Document. The other problem I see is that small businesses oftentimes have a family environment, so they don't feel the need to document performance problems. But you got to, because that always comes back to haunt you. So
Yes,
last
100%. 100%. Even like my company's not so big, I have someone doing HR because I first
Yep.
off found like I don't like it. Like it is I do a lot of compliance work and that was like in a different direction and I'm like I don't want to deal with this. And we've got the handbooks. We eventually had to put all that together because you start hiring people and you're like, well, what happens, in this conflict or that I don't know, what does the handbook say? Well, I guess I did the handbook, right? So
Right.
get your handbook, get your documents, and then Brandon, one last thing. Do you have any like interesting hobbies that you partake in?
I go to Disney World. Right now I stay less than less than 5 minutes away from Disney, so I go to Disney World a lot. That's one of my different hobbies now. I also work out and I exercise too. So those are my two hobbies. I like to pair Disney. You can easily do 20,000 steps at
Yeah.
Disney. If no problem.
I was gonna
So
say, like, if you need to get your steps in, you go to a theme park. Just the
go to
parking
Disney and just
garage.
walk.
Parking garage in. So we're like a Universal family because my kids are a
Oh,
little older than Brandon's are, and we love roller coasters in my house. So we are
okay.
Universal people. But just from like the parking lot to like the main gate, I think is like easily like 5,000 steps.
I was gonna say that's a 5K.
Yeah, I know.
Parking lot
Like
to the main 5K.
so last time I went to Universal, like I had to go to the chiropractor after because I was like carrying a lot of stuff because I was running around with my kid. She was there for school. I was carrying a lot of stuff in a backpack, standing, walking, and I was like, my back is killing me. I'm like too out of shape to go to a theme park at this point. But yeah, no, there's a lot of Disney fans out there, especially in Florida. You're in the right place now. You're in Orlando. You have all the Disney, everything you could imagine, and then some, I'm guessing. But that's very
Oh,
cool. What's the best way to contact you?
email as well as my phone number. You can drop both.
Okay, we'll drop
Email.
your email, your phone number. If hopefully people don't run in run into issues where they need your service, except for the preventative side. But
Yep.
you are in very good hands. If you have these problems, reach out to Brandon, and his whole firm is fantastic. We'll see y'all next time.
Next time.